My name is Carla Fredericks. First of all, I'd like to thank my wonderful colleague, Kristen Carpenter, my partner in crime, for working so hard on this conference. I feel like I was just happy to assist her. And Brad Udall, our colleague at the Getches Wilkinson Center, and also the law school for putting this together and allowing us this forum today to talk about these important issues. Our panel is about FPIC as it relates to land and natural resources. And I'm so happy that Professor Sosi gave such a rousing transition into this panel in her wonderful remarks, because this, to me at least right now, to where things stand in the evolution of FPIC and the UN Declaration is where the rubber meets the road, so to speak. So around the world, indigenous peoples have fought for centuries for recognition of their right to own, manage, develop, and have freedom over their traditional lands, territories, and resources. The international instruments, including the UNDRIP, emphasize that indigenous peoples' control over lands, territories, and resources enables us to maintain and strengthen our institutions, our cultures, and our traditions, and to promote our development in accordance with our aspirations and our needs. Indigenous peoples' relationship with our traditional lands and territories forms a core part of our identity and our spirituality and is deeply rooted in our culture and our history. Today, we're not talking just about the concept of free, prior, and informed consent, but the implementation of that principle and the obligations that flow therefrom. These obligations are on all sides, state, industry, and to the indigenous governments themselves to ensure that indigenous rights holders have the critical power of consent over their lands and resources. We're in a law school setting. I'm a lawyer, many of us in here are, and when we think of obligation, we think, especially as lawyers, what are the consequences of not meeting the obligation? Is there punishment? Is there an enforcement mechanism? In this country, this picture continues to develop. But what we want to talk about today is what the FPIC obligations are as to land and natural resources and the concept of risk. Risk as it applies to the holders of the obligation and risk as it applies to the holders of the FPIC rights. We will talk about the role of indigenous communities, the role of companies, the role of law, and the role of shareholders in pushing for best practices, especially with respect to extractive industries. According to the most recent report of James Anaya, the Special Rapporteur on the Rights of Indigenous Peoples, the worldwide drive to extract and develop minerals and fossil fuels, oil, gas, and coal, coupled with the fact that much of what remains of these natural resources is situated on the lands of indigenous peoples, results in increasing and ever more widespread effects on indigenous peoples' lives. Increasing resource extraction and its mounting effects on indigenous peoples make it all the more imperative to reverse historical trends and to secure indigenous peoples' rights in this context. As a starting point, there should be a broad understanding among all relevant actors about the content of the internationally recognized rights of indigenous peoples and about the principles that are to guide the actions of states, business enterprises, when these rights are potentially affected by extractive activities. Further, new business models for natural resource extraction need to be examined and developed, models that are more conducive to the full enjoyment by indigenous peoples of their rights, as the one that currently prevails in much of the world. In previous reports to the Human Rights Council, the Special Rapporteur has endeavored to shed light on the issues that indigenous peoples face in relation to extractive industries and to contribute to understanding of international human rights standards that apply in this context. So in the spirit of that directive, we have here with us today, both virtually and in person, an esteemed panel of persons who work daily in the field on these issues. First, our virtual guest and her colleague, Rebecca Adamson. Rebecca is Cherokee. She founded First Nations Development Institute and founded and currently heads First Peoples Worldwide, a nonprofit that works with indigenous communities throughout the world in engaging with governments and businesses to address the threat from rapid globalization. With her today is Dan Morrison, who is the founder of Imagine Social Good, a strategic consulting firm that works with social innovators to bring their ideas to life. Dan is the acting director of communications at First Peoples Worldwide and works with Rebecca Adamson on corporate engagement. Thank you for coming today.
Thank you.
To Dan's right is Shelley Alpern. She is the Director of Social Research and Shareholder Advocacy at Clean Yield Asset Management. Shelley is a shareholder advocate for nearly 2 decades, and she has worked on a wide range of issues, including climate change, corporate political spending, hydrofracking, toxic chemicals, and workplace diversity policies. Next to Shelley is Danika Littlechild. Danika is a member of the Ermeniscan Cree Nation located in Treaty Number 6 in Alberta, Canada. Danika is a lawyer practicing in the areas of Indigenous law, Canadian Aboriginal law, environmental law, and international law, and she is currently consulting legal counsel for the International Indian Treaty Council. She also works with various First Nations and Indigenous organizations, and she's done extensive legal research, policy, and work on the principle of free, prior, and informed consent in Canada and internationally. And last but not least is Nicholas Cotts. Nicholas is the group executive on sustainability and external relations group, and the Sustainability and External Relations Group working in support of global operations for Newmont Mining Corporation. Nick joined Newmont in 1994 as an environmental manager for a mine located in Peru. During his 11-year tenure in Peru, his role evolved into a social environmental focus, including community relations, external relations, sustainable development, and communications. He has since transitioned into corporate offices in Denver, Colorado, where he continues his important work as Director for Social Responsibility and Sustainability. So thank you for being here today. As I said, we'll start with First Peoples Worldwide and work our way through the panel.
Great.
I want to thank Carla, the law school, and I know the Natural Resource Department at the University of Colorado. This is just quite a moment. I was looking forward to being there with you all, and I still wish I could. But mostly I wanted to recognize this moment as the beginning of something new, something big, I think, not just for the Native Americans in the United States, but for globally, reaching out and really beginning to look at FPIC. We've been tracking FPIC for a while, and there's been 39 studies on FPIC done, of which only 4 engaged Indigenous peoples in the study of FPIC. So this is really a moment, and my hat's off to every one of us that are in this meeting today. I admire the lawyers and have known a number of you for years and years and years, and I'm getting to know some of the younger ones now, and just really thrilled with what this brings to our field. And the hard work and the struggles are evident in how much we've proceeded and how we've progressed and securing our rights. One of the things we've tried to do is not take a lawyer tack, but take a financial tack on this. And I'm on the mutual fund, the Calvert Social Investment Fund, and so we've really looked hard at how we can bring the market pressures to bear, or in other words, to make the market a financial case for Indigenous people's rights. I'm going to actually stop at this point and turn it over to Dan so you can see some of the results that we're finding out in the market that gives us some leverage, some key leverage points, and then I'll stay on for any kind of questions as we unfold on the panel. So thank you, and Dan?
Thank you, Rebecca. Appreciate it. And since we're talking about financial, in the spirit of full disclosure, I am Rebecca Adamson's son-in-law. I'm married to her daughter, Neva, now Neva Morrison. So everything I've learned about Indigenous peoples and Native Americans comes from Rebecca. So it's been an amazing honor just to be in her family, and it's very humbling to be in front of this crowd today. So thank you very much for having me. I'm just gonna quickly, I think many of you know about First Peoples, and this isn't a commercial, but it's more about talking about how Rebecca and the team came to the idea of doing this Indigenous Rights Risk Report that we're going to talk about today. So if you look at this map, these are all the communities around the world that First Peoples has worked with. Although there is an error, since Google Maps only allows you to pin 250 pins on a map, all of our South America pins got transferred to another page. So we've done a lot more work than this map actually shows. And so there's been this phenomenal work with Indigenous people around the world with the Keepers of the Earth Fund, small grants that are culturally appropriate, community driven. And then, but there is the other side, and it's corporate engagement. And this is something that Rebecca's been working on for a long time. And I think the most important point here is that a lot of people talk about capacity building in the world of development. And they always talk about capacity building of Indigenous peoples. But there's actually a lot of capacity building around FPIC and this work for actually corporations. And that's a big piece of the work that Rebecca and First Peoples does. And it's really in that spirit of how do we kind of build the capacity of both sides to come up with win-win solutions when we're addressing these issues and when we interact. So the major question was, why do Indigenous peoples matter to investors and shareholders, right? And there's been the legal track. There's the phenomenal work that's been done on UNDRIP and ILO 169 and all the other legal work that's been done. And that has really set up an amazing backdrop. And it's really, and sorry to use the word, but create a lot of power, right? And it's created a lot of market power. And I come from a corporate consulting background, right? And so when I sat down and started talking to Rebecca about this, that's really what popped in the front of my head. Is like, yeah, sure, there's the the legal case and there's going to the courts, but there's actually a lot of other power out there, and I think that's in the market, and that's really what Rebecca is focused on for a long time now, and the ability to actually make the financial case, right? So maybe there's a lot of investors and shareholders out there that, sorry to say, don't care about Indigenous people's rights at all, right? But we now have a tool and a language by which to talk to them and say, listen, even if you don't care, here's a reason why you need to pay attention, because it's going to hit you in the pocketbook, right? Or on the other side, and it's not always negative. There's definitely the benefit in the cost side of it. And here's just one quick example I wanted to run through, and it's Southwestern Energy. I'm assuming most people have heard about what's going on in New Brunswick with their shale gas hydrofracking site. And so, they're investing a lot of money. To date, they've stated they've now are probably over $30 million of investment in the site. And an analyst on October 6th stated that Southwestern Energy looks like a great long-term investment. And it is, and this I think is the most important point, it is a low political risk company. Okay, so then let's flash forward less than 2 weeks and go to October 17th. So that doesn't look like a low political risk in my mind, right? And so before this had happened, Southwestern had filed for an injunction at the court, which then the police came in, they arrested 40 people using rubber bullets and pepper spray, and this is the result. And then on October 22nd, actually, that court injunction was shot down, and the court said no. They're denying the request for the injunction to permanently prevent the protests from happening. And so the blockade is actually still in place. And that blockade is costing them $60,000 a day. That's not our number. That's not kind of the radical left's number. That is actually the stated number that Southwest put out. And it's basically the cost of the rental equipment that they are not able to use, right? And so that doesn't include, opportunity costs or lost profits, et cetera. So I think, this is a case, and it's a lot, as we all know, it's a lot about land. And I think some of the groundbreaking work and great work that Rebecca's done over the years is looking at land tenure. And so this is a series of maps. I want you to just watch how it changes and watch the yellow. So here's the 50s. There's the 60s, right? There's the 80s. There's the 90s. And we backtrack a little bit in Russia on this next map, but then watch Africa, right? So you see over time that, again, it's not just about UNDRIP, but it's actually about other, kind of legal wins that have been happening around the world that give Indigenous peoples more power in the courtroom, but also more power to then exert influence in the market in other areas of society. And so this is this is the kind of the first data out of our report. We found that so what we did was we took the 52 companies extractive companies, oil, gas, and mining, listed on the Russell 1000 index, all US-based companies, and we got a list of all their sites, and then we mapped them over indigenous territory in the United States and all around the world. And we identified 370 sites that extractive companies were operating on or near indigenous people's land, okay? And then we basically ran this risk assessment. And I'll get to that more in a second, but I threw this up front just to show that right now, 39% of the production by these extractive companies is taking place on medium to high risk indigenous land, right, according to our report. And that's only going to increase in the future, right? So when you look at reserves, actually that number jumps to 46%. And we feel that 46% number might be a little bit low because the larger companies like Exxon and others they don't report on a site-by-site basis, right? So we couldn't actually really get that data. They will report on like North America. So basically the point is you look at this map where indigenous peoples are getting more and more kind of control over the land, more and more of the things that people want to pull out of the land is actually going to be on their land. So, and this $60,000 a day at Southwestern is not an anomaly, right? So John Ruggie, who is the special representative to the UN on human rights, calculated that it costs $20 to $30 million a week to shut down a global mining site, right? He also found that the time to bring an oil project online has doubled over the last decade, right? So these are all what I would call cost multipliers. And then in addition to that, 73% of these delays are from, non-technical risks, which is a horrible bureaucratic term for stakeholders and people, right? And so these are not things that are happening underneath the ground. These are things that are happening up on the surface. So we were looking at that, and then there was a great report by, I know Rebecca, you want to say Arissa, because Steve Heim's here, but Aries found that 250 companies worth almost $3 trillion in market value have a high to medium indigenous people's risk, right, or indigenous rights risk. So we wanted to take that down to this level like I talked about. So we looked at 40 large and mid-cap oil and gas companies, and I'm sorry, it should be 12 large and mid-cap mining companies, and basically put them through, and here they are, right? I did the first map for this thing called Proud to be Indigenous campaign that pinned all these pictures of indigenous people all around the world. And then Rebecca came to me every time there was something to pin. She's like, you have to use Google Maps. But this shows all of the sites that we've done in the report. Again, only 250 of them, so there's 120 more. And then we put them through this methodology and this risk analysis. Basically, we looked at location. Is the site on or near indigenous land? And additionally, does it impact, maybe it's not on or near indigenous land, but it will impact a sacred site or something other very important to indigenous peoples. Does the company have an indigenous peoples policy? We'll talk more about that later, and I'm glad Newmont is actually here today. Reputation, are they able to manage their local, national, and global reputation? Is it positive, is it neutral, or is it negative? And then the country risk. We analyzed all the countries that these sites were in and looked at whether or not there were, everyone, yes, is recognized under it, but is there actually real recognition of indigenous peoples? And then is there also practical protection of indigenous peoples? And just a quick note on that is the lowest risk would have been the recognition of land. So there was no countries on the report that actually received the lowest risk of one. Community risk was the one we rated the highest because that was actually how the community was engaging with the company and the site. And so the highest risk here would have been some form of violence happening on either side. The medium risk would have been having no agreement. So maybe there's no dissension or there's no problems, but there's just no agreement in place. And then low risk would have been actually that there's an agreement in place. And then legal. And legal turned out to be, are there legal cases going on? And at the end of the day, we actually determined that actually wasn't a very strong driver of risk. It was more the results of a lot of these other things. Methodology, the sources we used, it was all publicly available information, 10Ks, annual reports, etc. We did reach out to several companies. We had a luncheon, and let me just stop real quick. I meant to mention this at the beginning. So Karen Chamberlain was a consultant that we worked with on this, and I know Shelley knows her very, very well. But Karen did much of the research on this and did a heroic effort at it. So I just want to give her a quick shout out for her great work, as well as Nick Pelosi, who is our corporate engagement associate at First Peoples, and both of them together just formed an amazing team on this. So she sat down and she had a luncheon with a lot of the oil companies that are located in Houston, and we have shared it. And so the process now will be actually to share this report with everybody, and we'd love to get Newmont and other people's commentary to correct things that we've gotten wrong, or just sit down and start to have that conversation. These are just kind of what it looks like. Here's the scorecard you'll see, kind of has the average score. We went through, we summarized each of the risk factors. And before I get to the summary of findings, this is a free report, okay? So this is something that you can find online right now on the First Peoples websites, firstpeoples.org/Indigenous Rights Risk Report with dashes in between the words. And there's also scorecards for the 52 companies, and those are also freely available. So if you just want the report, you can email us, email, you'll see at the end, nickpelosi@firstpeoples.com. If there is a deeper level of analysis that you want, if you want to look at Canada, or if you want to look at some part of the world, if you want to look at a certain industry, we're very happy to talk with you about engaging in that deeper analysis. And I think before we go through this too, the last thing I want to state, and I think this is Rebecca's biggest point for doing this, why did we do the report? We did the report because we really want to start building a bridge and building a platform for investors and shareholders in companies to directly have a direct link to Indigenous peoples, right? So a lot of times right now that there's just no ability for them, to just communicate, right? And so, I think we want to create that link, and then out of that will hopefully will come very productive things. And so if there's shareholder action that they want to take, or corporate dialogues that they want to have with the companies, we're hoping that this report will start driving that process. So let me just do a few quick summary statistics that came out of this. So out of the 370 sites that we analyzed, we found that 43% were on Indigenous land, right? And so that got the highest risk rating. 20% were high, and 36% were medium. We did not look at what would then be the low and the no risk sites, because they were not being impacted by Indigenous peoples. So of those 370 sites, what we found was 92% of them posed a medium to high risk to investors and shareholders, right? And that's 282 out of the 307 sites total. We then found that 74% of those sites, right, had a medium to high community risk. And that meant that there's no signed agreement with the community. And then potentially there's active protest or even potential violence at these sites. So if you think about this, let's even just assume that actually I think it was around 75% of the sites were medium risk. So let's assume you're just medium risk. You're like, well, that's not that big of a deal. That's a huge deal actually if you look at it and be like, wait a minute, there's no agreement with the community. Okay, and so what we really talked about as a team a lot was a lot of these sites were just one incident away from actually having a much higher risk for the company and for the shareholders. The other thing is that country matters, right? And what we found was if you look at all 370 sites, 18% of them are in critical, what we call high-risk countries, right? Ones that have no legal protection and almost no regard for Indigenous peoples. If you actually now look at the 21 highest risk sites, that doubles, right? And so as you go around so where companies decide to operate really makes a difference. And at the beginning of this, Rebecca and I actually just said, Rebecca, listen, I'm like, hey, if there's no laws or no protection of Indigenous peoples, that's the lowest risk, right? Because they're not going to, the country's going to be out of their hair. They're not going to care. They're going to be allies in this. And she's like, no, not at all. Rebecca, I'm going to speak for you, so wave furiously if you want to say something. But she's like, no, actually what will happen is that companies will do things that they normally wouldn't do, let's say in the United States, which would be a lower risk country, and therefore bring to the attention all these other risk factors, right? They're going to get more hammered in reputation, they're going to get more hammered in community, et cetera. And that's actually what we ended up finding in the study. So, Rebecca, you're looking calm, so I'm going to move on. There you go. So of the companies that have 10 or more sites on Indigenous land, about 25% of our sample, again, 92% of them had at least one high-risk site in their portfolio, right? And, again, one site might not seem like a lot, but we know sometimes the fickle nature of financial markets, and sometimes, the big splash on the media can have a much bigger impact on shareholder value than something substantive. So, and then 23% of these companies had over 5 sites with a high risk. So again, we kind of, we'll wrap up here in a second. So 21 of the 21 highest risk sites, 68% had critical reputation risk, which means they were getting negative global press across the board. And then 64% of the sites had critical community risk, which meant that there was beyond nonviolent protest, there was actually some serious community opposition going on. So at the end of the day, basically it says if companies don't develop a positive working relationship with indigenous peoples, the risk goes up. And I think that's probably very intuitive. It makes a lot of common sense. But now we actually have the data and the examples to show that. And I'm glad Nick was here, and I said, and this was the slide why, because of all those companies, of all of these companies, 64% that have critical community risk, there's only 5 companies out there of these 52 that actually have FPIC policies. And there's only one of those companies that actually explicitly states that they will follow FPIC. And I'm sorry, only 5 have indigenous peoples policies. Only one truly explicitly states that they're going to follow FPIC. And which one do you think that is? Trick or treat? So Newmont. So we're happy that they're here today. So, and that's insanely troubling, or very troubling, because 69% of those companies are facing 100% of their sites are facing a medium to critical risk, right? And so they're kind of in the report, we say they're kind of flying very blind on this issue. And this is not going to go away, right? This is, I don't know if you guys read Malcolm Gladwell's Tipping Point, but he talks about this confluence of almost sometimes unrelated issues coming together, and that's what's happening here. So we have indigenous people's rights, and their ability to enforce them is just increasing every day. You kind of see it in this room. More and more oil and gas and minerals are actually being found on indigenous land. So it's just going to, the corporate and kind of the extractive industry is going to find themselves there more and more. And then, there's the kind of indigenous peoples and their allies are able to use digital media more and more. And I think someone at the SRI conference earlier this week compared it a little bit to the Arab Spring, right? And so where the Arab Spring, there's all of this attention to pay to, was this the first Twitter or Facebook, revolution, right? But, I'm not sure if that is true, but it definitely played a part and allowed people traditionally who can't get their message out to get their message out. So I think these 3 things together really speak to the rising risk. So again, this is freely available for everybody. Here's the email. You can email if you want a copy of the report, which is online, and then any of the scorecards. Or if you want some level of deeper analysis, we love to entertain those conversations. So I'd like to thank Rebecca for letting me to be part of all of this, and I'd like to thank all of you, and especially Carla for inviting us to this phenomenal forum. Thank you.
Good afternoon. I just turned afternoon. I almost said good morning. I have to put my thing on there. Well, while you're doing that, I will. There it is. Do view and then slides. Slideshow. No, you didn't. Okay. Good afternoon. My name is Shelley Alpern. I'm with Clean Yield Asset Management. We're based in Vermont. I'm the Director of Social Research and Shareholder Advocacy. Our firm we manage about $230 million for high net worth families and individuals. And we fall within a subset of the larger investment world that is sometimes known as sustainability investors, or SRI investors, standing for socially responsible. All sorts of names are thrown at us or being debated in our own community about what to call ourselves. So I'll use a few of these terms as synonyms. My job is that I'm a shareholder advocate, and what that means is that I will approach companies that are in our portfolios and try to advocate for best environmental and social and governance practices for ethical reasons as well as for financial reasons. So I would be, a typical day for me is to call up someone like Nick from Newmont and be talking about the specifics of, say, indigenous policy or something else. Now, we're not unique. Our trade association surveys the field to see how many people think of themselves in some way, shape, or form as sustainability investors. And the last time the survey was released a year ago, about, if you use a really broad definition, if you include everybody, for example, who won't put tobacco in their portfolio, you're talking about 3.75 trillion. It's really grown. It was about 600 billion in 1995. And there are strong networks internationally as well as in the United States. And if I do my job right in the next 15 minutes, hopefully you'll feel as if our worlds have collided because, and I mean that in a good way, not in a 1492 kind of way. And that's because most of the general public and doesn't know, or even specialized publics like this one, don't know that investors do take stands on ethical issues and are using some of their leverage at companies to advocate for better practices. And in a lot of cases, particularly among sustainability investors, if there's a project that we think is ethically just off the charts, and that would be a project that that's going forward without indigenous consent, we won't invest in it at all, or we may take steps to try to stop such a project. And I'll give an example of that a few slides from now. Okay, so I'm not going to, well, this slide is about why FPIC should matter to investors and not just sustainable investors. And I'm not going to belabor the points that were just made because Dan just made them brilliantly. It's basically that, it could cost companies a lot of money. That's the bottom line, even if you don't have an overlay of ethical considerations. And I'll just move on. There is a growing awareness of FPIC issues among investors. There's a little tiny bit of history here. Going back to 1998, Calvert Group, and Rebecca sits on the board of Calvert Group, became the first mutual fund to incorporate a standalone indigenous rights screen. Other leaders in this space I've just put up there. I want to point out that Boston Common Asset Management has been a real leader in this space, and we're very lucky to have Stephen Heim with us from Boston Common, who has done great work, which I will be talking about a little bit. So I have to leave right after this presentation, but Stephen's a great resource if you want to talk about this issue further with him. And our trade association sponsors an Indigenous Peoples Working Group that Carla's part of, Rebecca's part of, and maybe even some other people who are attending the conference right now. This conference, and Stephen, of course. He chairs it. My apologies, Mr. Chairman.
Susan White, Jan Bryan, chair of the Indigenous Peoples Working Group.
Okay, yeah, Susan White from the Oneida Nation of Wisconsin. So what do investors bring to advocacy efforts? First, we have direct access to corporate management. They'll take our calls. And we have the ability to file shareholder proposals, which, I mean, most of you are either lawyers or lawyers in training, so you probably have a passing familiarity with them. They're non-binding, and when we file a shareholder resolution, it has it has some, it basically gets the issue to the attention of the board of directors in a timely manner. So we use it when there's a sense of urgency, when we have a sense of urgency around an issue, or where if we're having a dialogue with a corporation and it's proceeding too slowly, file a shareholder resolution. It's basically you file it, and then 6 months later, it could come up to a vote by all the shareholders if you haven't reached some kind of win-win sort of withdrawal agreement with the corporation. We also bring expertise in estimating what the financial risk to corporations can be from mismanagement of community relationships. I'm going to come back to this one that's misordered. In this history of advocacy from investors on Indigenous issues, there have been some successful things, events, developments which investors have contributed to, and I really need to underline the word contributed. Every time there's a victory, it seems that there's for every victory, there's 10 advocacy groups who want to claim victory, and that's not what I'm doing here. But just a few examples. And the first bullet point are things that Stephen Heim has worked on with his firm Boston Common. ConocoPhillips changed its human rights policy to be consistent with ILO and UNDRIP, and it sold its interest in disputed Peruvian Amazon oil concessions. Those developments have happened in the last few years. Pebble Mine, Anglo American, just recently announced that it's going to be withdrawing from this project to develop a mine abutting Bristol Bay, which has been opposed by many Alaskan nations because of its threat to salmon. And that's the example I wanted to point out where social investors are not just trying to reduce the risks of projects, we will advocate against them if we think they are fatally flawed. Way back, when Home Depot joined the Forest Stewardship Council in '99, shareholders had been involved in filing shareholder proposals to get that to happen. Repsol developing an Indigenous relations policy was also something that Stephen worked intimately on. And overall, this is just a subset of some of the work that investors have done. Rebecca and First Peoples Worldwide have tracked about at least 50 resolutions on Indigenous issues since 1993. These are some of the other issues that dialogue and resolutions have been about. And we also will lobby other actors in the financial community on Indigenous issues. I'm not going to go over all these bullet points, but I wanted to point out one example is 19 institutional investors that collectively managed $20 billion, urged the U.S. State Department to endorse UNDRIP in 2010. And one thing that I worked on was a shareholder proposal at RBC in Canada, pressing them to report on its financing of tar sands. And that was something we worked on with Rainforest Action Network in our dialogue with that company. And it also resulted in them making changes to internal documents so that their lending officers have to track whether Indigenous consent has been obtained on projects that they are underwriting. I mentioned the opposition to Pebble Mine that is ongoing. These are some other dialogues that are also continuing with corporations. With members of my community. Newmont should be up there as well. And another example of collective action that is just recent, it was a joint letter from investors to the Canadian Oil Sands Innovation Alliance that incorporated an ask around FPIC as part of developing best practices. Now, FPIC shareholder proposals in particular, the concept has been either implicit or explicit in a few proposals. The specific proposals where FPIC has been mentioned were filed at Weyerhaeuser in 2008. It was by Calvert Group. It was withdrawn, and Calvert actually ended up divesting from Weyerhaeuser because they felt that the company wasn't responding as it should and had failed to cease clear-cutting in the face of indigenous opposition. The ConocoPhillips resolutions, as I mentioned, were filed by Stevens' firm. And this is just a quote from First Peoples Worldwide, actually, back in 1998, noting that, that the involvement of the social investment community had helped change the behavior of corporations. And if that was true in 1998, it's even more so in the years that have lapsed since. I'll just leave you with a few useful links. The second one is our...
We didn't pay Shelley for any of this.
No, they really didn't. So I'll leave that up for a few minutes, a few moments before the other speaker comes up. And thank you very much for your attention. I hope it's been useful.
Next one.
It only took me 4 months to unlearn Mac.
Good afternoon, everyone. It's a pleasure to be here sharing a bit of your day with you. As indicated, my name's Nick Cotts with Newmont Mining Corporation based in Denver, and I guess stealing a little bit from Shelley, I wanted to say that I'm a responsible mining advocate, and that's internal to my company, and that's really a role that I play within Newmont's organization, is really helping Newmont internalize and understand what responsible mining means, and to push our organization in that direction when it needs to be pushed in that direction. And that's a role that I truly enjoy playing. What I want to do today, sitting this morning and listening to the first panel, I must admit, and in the full spirit of disclosure, I feel completely inadequate to stand up here in front of all of you and talk about free, prior, informed consent, because all of you are legal experts and have indigenous people's experience and expertise that I can only dream of ever having. So I'm very humbled in this audience and certainly respect the expertise that exists here and hope that I can learn something from all of you as well. The other thing that I would like to be transparent about is I'm not a lawyer. I actually went to the school up the road at Colorado State University, so I hope no one here holds that against me as well. And I think with that I'm fully disclosed. The things that I would like to talk about today is really three things, and I think it's important to understand from a company's perspective what is the evolving context that we find ourselves in as a business around free, prior, informed consent, and how does that shape and change our policies, how does it shape and change how we view our business and how we develop our business. The other point is really translating the concepts of policy into practice on the ground, and I think that that's a huge challenge that we collectively face and share, is that translation of the legal terminology into relationships and practice and agreements and engagement practices on the ground. And that's something that all of us are struggling mightily with. And as one of the speakers previously talked about, was You know, we can have all these sessions and engagements, and I'm involved in a number of engagements where we don't even have any Indigenous people in the room to talk with us and help us understand what we're talking about. And so that marrying of the people and the impacts that we're talking about together with the policy, together with the companies, is really important. And until we can get all of that happening together, we're not going to really make any meaningful progress in terms of translating policy to practice, and that's important. The last one I want to talk about is just the challenges that we see ahead, or that I see ahead, trying to translate this policy into practice. So what is the evolving context? Sometimes what's important for us, and the discussion of free, prior, informed consent as it relates to Indigenous people has been building for a long time, and we heard that this morning in terms of the permanent forums and the UNDRIPs and the guiding principles on business and human rights. And all of that is part of the evolution of what role does business play in this, and what is our responsibility around rights, Indigenous peoples, and free, prior, informed consent. But to sometimes step back and stop where we are and turn around and look back is really important to do. Why? Because sometimes the change is painfully too gradual for us, and we feel like we haven't actually made any forward progress. But when we stop and turn around and look, we can see exactly where we've come from. And I think that to some of us, that's gives us a good feeling, and to others, it may not give us a good feeling because it's such a slow, gradual change. But I think it's important to do that. In the terms of the human rights context, we heard some discussion about that this morning, whether free, prior, informed consent consent is a right, or it's a principle that impacts rights. But from a business perspective, what we've seen is this translation over a period of time of governments being responsible and needing to promote the rights of Indigenous peoples, to the integration of businesses' responsibility around Indigenous peoples' rights, and the role that business now has under the guiding principles from the United Nations and Ruggie's work around human rights, and certainly around the rights of Indigenous peoples and the principles around free, prior, informed consent. From an international standards perspective, which is some of the standards that we have to follow, or we choose to follow as an international corporation, there's a couple things that stood out in my mind. One was the extractive industry review process. How many remember that process that happened in 2002, started about then? But that was really the World Bank, and there was a number of hands that went up for those who couldn't see the hands. But that was really the World Bank asking themselves, should we be involved in the extractive industry? And whether it's with governments or the private sector arm, the International Finance Corporation, on financing the extractive industry, and under what conditions should that involvement continue, if it should. Free, prior, informed consent was one of the key topics that was discussed throughout that whole extractive industry review. The International Finance Corporation's response to that was the 2006 version of the performance standards, which they use for the extractive industry and financing that they choose to do. And that standard around that spoke to free, prior, informed consent at the time was free, prior, informed, little c in my vernacular, consultation. And that was the language that the World Bank and the International Finance Corporation landed on through that process. And my belief in part was that because many people didn't understand what consent meant. And so that created challenges around the World Bank's position globally for consent. The International Finance Corporation has since evolved its performance standards. In 2012, they reissued their Indigenous Peoples Performance Standard, Performance Standard 7, and they've translated that to free, prior, informed consent. And today, the standard for the International Finance Corporation lending to the private sector is free, prior, informed consent. So we've seen that evolution change from consultation to consent. One thing that's very important to note, I think, is that business that works under these standards have been trying to work towards the free, prior, and informed piece now for quite a number of years. And only recently has the big C consent come into the normative framework from the World Bank perspective. On the industry leadership side, I'm just going to mention the International Council on Mining and Metals, and that's really an international body that represents some of the leading mining companies globally, and they've been tracking also in terms of their policy development the IFC performance standards and the international discussion and debates on free, prior, informed consent. In 2008, they developed an Indigenous Peoples Position Statement, and in 2013, in May, we just released a revised version of that statement, which translated the concepts of consent into that position statement. So it provides some guidance and some requirements in terms of commitment from its member companies to be operating from a free, prior, informed consent perspective in projects that involve Indigenous peoples and Indigenous territories. Finally, I wanted to just mention business risk management, and we've heard Shelley speak to that, and we've heard Dan speak to that, and others today as well. And I think the point that I want to make is that there are increasing shareholder pressures that are mounting on businesses, and Newmont, as an example, had one of those resolutions that came in 2007. And our board of directors chose to accept that resolution and take the challenge on, which was really around questioning the policies, the procedures, the practices that we were using around the relationships and the community relationships around our operations. And so we went through a 2-year process of independent review to understand how well those policies, practices, and standards were working to manage risk from a community relations perspective. And that resulted in some important changes to our standards and the way that we thought about the relationships that we were building. Some of those absolutely come and overlie the thinking around free, prior, informed consent from our business perspective. So let's talk a little bit about translating policy to practice. One of the things that we started to realize as an industry and as industry leadership when we started to talk about free, prior, informed consent, when we started to engage external to our companies around that, we found out that there wasn't a common language that was being used, and there wasn't a common understanding or a set of experiences that we could draw upon that really helped us understand what free, prior, informed consent means from a business context. I think there's a lot of great practice out there. There's a lot of really bad practice out there from a mining company perspective that we need to look at and we need to draw on, because I think that the good practices that we can use and shine lights on to help other companies understand what good community relations practice, what engagement looks like, what good Indigenous peoples practices look like. We have a number of experiences that we can point to that are good. One was mentioned by Dan and is in their study, and it's our Ahafo mine. And we developed an engagement process there which was called the Ahafo Social Responsibility Forum. And that forum consisted of 56 different stakeholder groups and representatives that the company sat down and started to engage around the project, around the relationship between the company and the communities, the traditional values, the benefit sharing. And that process really created a very effective engagement mechanism that we could use to communicate, dialogue, understand the issues that communities had with our project and make changes into our project. That was a good example that we can draw on as we now translate that out to Indigenous peoples projects. Agreement making. We've got a number of examples, the Ahafo example, another one where we've had 3 agreements that we've been able to develop with the communities. One was around employment. The other one was around the relationship that we have and the commitments that we as a company must make to the community, but also the commitments that the community is making to us in terms of the relationship. Not that they're making commitments to us, but they're making commitments to the relationship in terms of how are we going to behave together when we have disputes, when we don't get along. Because it's a relationship, and all relationships have bumps, and we need to be able to have policies, procedures, and practices of how we navigate through those. That's an example. We have some other examples in Australia with some of the traditional owners and the projects we have there of agreement making in terms of benefit sharing, in terms of environmental participatory monitoring, that we can look at and pull examples from to apply to other Indigenous people scenarios. Expectation and relationship management, that really, I spoke about that earlier with respect to the relationship agreement that we had. The next one I want to talk about is this Resolve Solutions Network and free, prior, informed consent dialogue. A couple of years ago, a number of us companies were sitting around talking about the need to start to articulate practice around free, prior, informed consent. And we started talking with a number of our civil society partners and organizations that are focused on this, as well as other companies. And we came up with this concept of saying, how do we sit down together, put together a platform that we can start working from to operationalize the concepts of free, prior, informed consent so that we know what it means. And so a number of us, including a number of the NGOs and civil society organizations in this room, and First Peoples Worldwide was at the second meeting of that group, and we really appreciate that participation, hope it continues. But Oxfam America, Earthworks, First Peoples Worldwide, Forest Peoples Program, Newmont, Rio Tinto, the BG group on the oil and gas side. So we have a pretty diverse group of companies and civil society organizations who are rolling up their sleeves saying, let's figure out what this means. Let's figure out how to translate the practices that we're aware of today in terms of F, P, I, and C, and how we can change those, make them better so that companies have some knowledge and ability to determine what's working, what might work better. The focus of this is really then to bring these indigenous communities together with NGOs and companies and have that dialogue and create a safe space where we can really bring the discussion down to practical, on-the-ground things that we should be looking at, questions we should be asking, practices we should be developing in order to understand how to apply free, prior, informed consent. The other piece of this was to identify different pilot projects or scenarios that we could collectively bring, whether it was civil society bringing an experience, companies bringing an experience, to say, here's a great example of something that went wrong. What can we learn from that? Here's a great example of something that went well. What can we learn from that? And so it's really creating this learning-based network of practitioners around on-the-ground experience to help us move forward in defining what free, prior, informed consent means in the areas that we're developing projects. So I want to just share a little bit about one of the projects that we have where we're going through this. And so my role as an advocate within Newmont was to, as I came back from Africa, I walked into the corporate office and they said, great, we're developing a project in Suriname. And I didn't even know where it was on the map. So for those of you who don't know where it is on the map, I thought it doesn't work. Let me do this.
There it is.
I would put that up there. And so Suriname sits up in the northeast corner of the continent of South America, and it's sandwiched between Guyana and French Guiana. And Suriname has an interesting history around free, prior, informed consent and indigenous peoples and tribal peoples and the relationship with the government. And the reason that I wanted to share this with you in my role as an advocate was I walked into our leadership in the organization. I said, does anybody know anything about Suriname here from a tribal people's perspective, from a international court perspective, from the risk that this project could pose to us around free, prior, informed consent? And the answer was, no, not really. I mean, yes, a little bit, but not really. And so I've been advocating for about 6 months to say, this is a big deal. We need to understand it. We need to take time to engage with the tribal groups in which this project is located to determine whether we do or don't have free, prior, informed consent and how we're moving forward with this project. And so we've put this project as a pilot project, if you will, into this free, prior, informed consent dialogue so we can learn how can we do things differently as we move through developing this project. And that project hasn't started construction and it hasn't been approved by the board of directors yet. But what we're really trying to do is look at the environmental social impact assessment consultation process. How did that actually inform the community? Did it inform the community? What's their understanding around the project? And we actually sent an independent consultant to go in there and talk with the communities, engage with the indigenous peoples, and find out, what do you actually know about the project? And his conclusion, when he came back, he said, I think you have free, I think you have prior, uninformed consent, right? Which was really important to us because obviously the consultation process through the ESIA requirements did not meet the needs of the community in terms of informing them about the project. So we've changed and revamped our whole process of community engagement so that we can achieve an informed community around this project. So that's just a quick snapshot example of how we can start to use some of the tools and concepts of what this means in a very project-specific context to change our behaviors, to change our approach in terms of how we engage with the communities. The other one that I just want to speak to here is the PAMICA Negotiating Committee and the letter of intent. One of the things that we ran into as we started to look at free, prior, informed consent and this Indigenous peoples community was, what is their capacity to engage with the company? What is their capacity to understand free, prior, informed consent, to understand their rights, to understand what the government thinks of free, prior, informed consent or rights? And we found that they don't have very good capacity to engage. And so through their own thinking and through a little bit of support from us, they developed a negotiating committee that we can now speak with that represents the broader community. And so we were able to develop a letter of intent, and that letter of intent with them simply states what our commitments are to them in terms of how we're going to behave. It recognizes their rights and recognizes them as an indigenous peoples and the rights that go along with being an indigenous peoples and a tribal group in Suriname. And they also recognized our right that had been given to us from the government to explore on their land and to continue to negotiate with them in a partnership around what an agreement would look like if an agreement should be developed in terms of their consent to this project going forward and what that might look like. So we have a process that's been laid out in a high level that we're moving through with that tribal group, which again gives us another framework to be able to push into this dialogue to understand what concepts of free, prior, informed consent look like. And I'm on my last slide, and I have 0 minutes left. So what are some of the challenges that I think are ahead of us as we all have to struggle with what's the practical applied concepts around free, prior, informed consent? Because projects are going to continue to be developed, and they're going to continue to be developed on indigenous people's lands. And so we must understand and start to understand what these concepts mean and how we should be using them as a business and engaging and determining whether projects should or shouldn't be going forward. Experience and learning is something that I see as a challenge, and I see that as the risk is not casting the net wide enough to pick up all the different experiences that exist out there that we can learn from, and we can pull little nuggets of good practice and bad practice so that we can have a better set of informed information, documents, practices out there to help us and guide our learning as we go forward. I spoke about Indigenous community capacity building. I think, Dan, you mentioned that as well. We see this as a huge gap that it's not really a company's role to fill this gap. And we can participate in that, but we really look to the international community to help fill that gap and to help build capacity where capacity is needed. Company capacity building. This one goes right up along with the indigenous people's capacity building. Companies need to understand what free, prior, informed consent is. Right now, it's the fear factor that exists in companies, and maybe that's a good place to start, and probably is, but we have to help pull that apart a little bit and turn it into something that companies feel like they want to engage in and they want to understand how it applies in their business context so that they can make forward progress, they can have better policies, they can have better practices, they're going to develop better projects that do have consent, and they'll know which projects they shouldn't be developing because they don't have consent. And finally, industry leadership. I think that we need to have leaders in the industry stand up and take this concept on and try to internalize it into their business. And it's the leaders in the industry that are going to do this who are going to be the trailblazers, so to speak, to helping us operationalize free, prior, informed consent. And we need, I think, my view is let's try to support those leaders, encourage them, help them find out when they're making mistakes and doing good things in terms of relationships, agreements, and engagement, and really encourage that leadership to continue to push the bar, because without that leadership pushing the bar, then the rest of the industry is not going to come along. And so I think that's a challenge that we have of not getting too far out ahead, but two, really helping leaders drive change within the extractive sector. So with that, thanks for the opportunity to be here. And we're certainly not perfect and we haven't got it all right, but we're trying, and we appreciate the opportunity to do that. Thanks.
Can I close this?
Dan sa tuya kakeo, kinanaskom tanawaw, ota piantumiek. I don't know about you, but I'm starving.
No, that's not actually what I said.
I actually said I wanted to thank all of you. I'm very honored to be here. I'm very pleased to have been invited by the University of Colorado and to be here on behalf of the International Indian Treaty Council, which is an NGO which holds general consultative status at the UN, working on behalf of indigenous peoples in the Americas, the Caribbean, and the Pacific. I've been working with IITC for a little over 2 years and have been practicing law in Canada for about 11 years prior to that. And so I'm really thrilled to be here. It's my first time speaking at a U.S. law school, and I was telling a friend of mine earlier that it's a bit of culture shock for me. We do things a little differently in Canada, and so it's a lot of fun to see how you guys engage at this level in dialogue on a principle like FPIC, and so I really hope that I can make a positive contribution to your conversation today. So I'm Danika, Littlechild from Canada. I'm from the Ermineskin Cree Nation, which is located in what we call Treaty 6 territory. In Canada, our treaties are part of our federal structure. In other words, our treaties are foundational documents forming part of our Constitution. I think they're supposed to as well in the U.S. I think it actually says that in the U.S. Constitution, but I'm hearing some opposite viewpoints or some evidence to suggest otherwise. But in Canada, our treaties and our treaty relationship are in fact fundamental to how we interact with the rest of Canada as well as with the international community. And so I come from that perspective. I also come from an interesting perspective in the sense that I come from a First Nation, or as you would call it here in the States, a tribe, which actually went through an era of development of oil and gas extraction. And now we're at the end of that development. As many of you probably know, non-renewable resources do eventually run out. Okay, and so I come from a place where we're experiencing what happens after they run out as Indigenous peoples, which I think is a fascinating conversation to have, because so much of our dialogue, whether it's nationally or internationally, and even the way we characterize FPIC, is we always talk about before developments. And so really, I'm coming from a place where we've experienced what it's like to go through the development era and come out on the other side, and what does that look like for us. I'm not sure that I want to spend too much time on that, but I thought I'd just let you know. So if you want to pull me aside in the hallway and grill me about what it's been like for us, I would be happy to talk to you about that. But what I'm really interested in getting at today, because I know we're really kind of over time on our agenda and we are hungry, we need a bathroom break at some point, I want to touch on two things with you today. The first is I want to talk to you about bringing the dialogue on this panel back to the title, which includes the phrase natural resources. That's the first thing I want to talk about. And the second thing I want to talk about is something that was alluded to by our Navajo representative, which was some of the work that's been going on internationally around business and human rights and how they intersect. So let's go back to my first topic. What I find really interesting, and part of the culture shock for me being here today, is that in Canada, we actually spend a lot of time talking about the laws of Indigenous peoples. What do I mean by this? I do not mean the laws of Canada that were written without us, about us. I mean our Indigenous laws. And my Navajo colleague here alluded to some of those traditional, customary, natural laws which the Navajo have codified and done so in a way that's understandable or cognizable to other Americans or to members of the international community. In Canada, we're really interested, I think, at a national, regional, and local level as to how can we return to those concepts of Indigenous legal orders as something that is fundamental to the process of implementing the Declaration on the Rights of Indigenous Peoples, but also fundamental to a better relationship on a go-forward basis. How can we strengthen our relationships between Indigenous and non-Indigenous peoples? And part of the reason I think that in Canada we're seeing a resurgence of this focus on Indigenous law is because for many years, for us in Canada at least, it was illegal for us to hire a lawyer to represent us up until 1951. It was illegal for us to attend law school to become lawyers ourselves. And we saw a court system where in order to what I call litigate our identity or try to prove our rights within these mainstream courts, we would have to hire non-Indigenous lawyers who were trained in mainstream law, common law for us in Canada, or civil law for those in Quebec, and apply that law to Indigenous peoples and try to bring in anthropologists and ethnologists to tell us who they are, as opposed to asking Indigenous peoples, so who are you? Yeah, so that was a few decades in the works, and I will not claim extensive knowledge about what has happened in the U.S., but I'm guessing it's a little bit similar. And so at this point now, we're seeing more and more Indigenous people who are trained in the mainstream legal order, your U.S. law, legal system, and our common law system, our civil law system in Quebec. But we are also very interested in training ourselves and understanding how do we bring Indigenous identities and true identity, true descriptions of who we are to bear in these types of conversations. And so I think that's something worth mentioning for the law students in the room. There are other legal orders out there, and there are other knowledge systems out there that could be important in the type of work that you endeavor to do. And in fact, there's a law school in Canada that is considering starting up a Bachelor of Indigenous Laws to be taken concomitantly with a Bachelor of Common Law, so that when you finish law school, you have a dual degree. We do the same thing with Quebec. We have a Bachelor of Common Law, Bachelor of Civil Law. We're looking to do that at the University of Victoria in British Columbia. And so that concept of there being other legal systems, I think, is really important premise for me to start from with you today for my portion of the panel, because I'm coming from a very Indigenous focused perspective. I used to like to tell my clients in Canada, I didn't go to law school to become an Indian agent. I'm not here to impose Canadian law that's been made about us upon my own people. I'm here to do no harm and in fact to help my people, and part of that means being a critical thinker about the laws that we're talking about. And I think that's also very important. And so the first point I wanted to get to was to go back to this concept of natural resources. And I think it's really important to also mention that there's been a lot of work done by the three main UN mechanisms that exist pertaining specifically to Indigenous peoples, namely the Permanent Forum on Indigenous Issues, which ought to be renamed the Permanent Forum on the Rights of Indigenous Peoples, but that's another matter. The Special Rapporteur on the Rights of Indigenous Peoples, and finally the Expert Mechanism on the Rights of Indigenous Peoples. That trifecta of UN mechanisms that has been established to address issues pertaining to Indigenous peoples has spent a lot of time actually talking about this concept of FPIC, and I think it's worth mentioning, and I think it's worth putting your mind to in terms of engaging in interpretation of what this principle means and what is the content of this principle. And so I want to take you actually to a report that was done by the Expert Mechanism, which was a follow-up report on Indigenous peoples and the right to participate in decision-making with a focus on extractive industries. And this was released in April of 2012. So if any of you want the link, I can certainly give that to you. So that report, I think, makes a very important point, which I haven't heard made yet today, about the Declaration on the Rights of Indigenous Peoples. And that is that this declaration and the articles within it are not meant to be stripped apart and have each article read on its own. Much like other human rights instruments and other international standards pertaining to human rights, specific articulations of rights are not meant to be standalone, understood on their own as a singular paragraph or a few sentences. These instruments are meant to be read cohesively. They're meant to be understood as having articles that relate to one another and which contribute in turn to their interpretation. Much like state legislation, which may have a preamble and articles. Well, what's the purpose of the preamble? It's to set the context and to help you understand what the articles really mean, how the articles and sections of a piece of legislation relate to one another. Similarly, I really urge you to read the Declaration as a cohesive whole and try to understand the linkages between those articles. This is what the Expert Mechanism tried to do in the report in 2012. They took us back to some work, very important work that had been done by Madame Diaz in the year 2000, I believe. She was a special rapporteur who was appointed by the UN to talk about Indigenous peoples' permanent sovereignty over natural resources. Now, that is a phrase that will scare governments. That is a phrase that will really frighten national governments like the US and Canada, I'm sure. This concept of permanent sovereignty over natural resources, what is that and where does it come from? Well, where it comes from is actually it comes from 1966. It was a concept, permanent sovereignty over natural resources became a general principle of international law when it was included in Common Article 1 of both the International Covenants on Human Rights. And so Common Article 1 provides that all peoples have the right of self-determination. That sounds familiar if you know about the UN Declaration on the Rights of Indigenous Peoples. We know that actually this Common Article 1, that first sentence, was very important to what was articulated and described in the UN Declaration with respect to self-determination. The next sentence reads, by virtue of that right, they freely determine their political status and freely pursue their economic, social, and cultural development. 2, and here comes the permanent sovereignty part. All peoples may, for their own ends, freely dispose of their natural wealth and resources without prejudice to any obligations arising out of international economic cooperation, based upon the principle of mutual benefit and international law. In no case may a people be deprived of its own means of subsistence. So this is Common Article 1 for the foundational international covenants on human rights, which of course the U.S. is definitely party to, as is Canada. So why does this matter? Why bring this up for Indigenous peoples? So here's when I want to get to a little bit of the analysis, and I hope you'll be able to follow me on this. So let's keep our permanent sovereignty in our minds. Now we think about the right to participate. The right to participate in decision making. It kind of seems related to this concept of free, prior, and informed consent, doesn't it? That if you're going to give consent, shouldn't you be part of that conversation somehow? Shouldn't you be participating in the process somehow? Well, that right to participate is set out in the UN Declaration and is considered to be indivisible and interrelated with other rights, like the right to self-determination, rights to lands, territories, and resources. So even though the right to participate has been a huge focus for these 3 UN mechanisms for a while now, the mechanisms also tell us that we should be reading these rights holistically, understanding them as a coherent whole in the light of the rights of Indigenous peoples pertaining to extractive industries more broadly. And so as a fundamental right, self-determination is best exemplified and fully enjoyed by Indigenous peoples when it's exercised in relation to lands, territories, and resources, especially in regard to extractive industries. And so when you're going to implement Articles 1 and 3 of the UN Declaration on the Rights of Indigenous Peoples, then we have the right to the full enjoyment of Common Article 1 of the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social, and Cultural Rights. And that's what I read to you earlier. This concept of permanent sovereignty over your natural resources. And so the Human Rights Committee has called upon states to act in accordance with Article 1, Paragraph 2 of that common article in relation to Indigenous peoples. And they have told states, not just the U.S. but others as well, that the right to self-determination requires that all people must be able to freely dispose of their natural wealth and resources and not be deprived of their own means of subsistence. And so, so remember I kind of made the distinction a little earlier that that common article has 2 parts, right? The first part talks about self-determination. That is what appears in the UN Declaration on the Rights of Indigenous Peoples. It's only paragraph 1 that got in. And so the content of paragraphs 2 and 3 of that common article, while they're not in the same space as that self-determination one in the UN Declaration, they are found elsewhere in the UN Declaration on the Rights of Indigenous Peoples. If you look at Articles 23 and 32, that brings in that idea of permanent sovereignty over natural resources. And so it's a bit of a complicated analysis, and I wish that there was a blackboard or a whiteboard or something like that so I could kind of sketch it out for you. But basically, it is to say that that concept of permanent sovereignty over natural resources must come into play when you think about what FPIC means in the context of the UN Declaration. In other words, don't just look at the UN Declaration and say, okay, we've only got one section that talks about FPIC in the context of toxic waste dumping or something like that. That's the only time we should consider it. I don't believe that is at all the case. And I think that we need to look to the experts who have been appointed to these UN mechanisms to assist us in understanding how we should interpret and implement these rights. And very quickly to my final point, which I think is important, to briefly touch upon what was mentioned earlier, that there are in fact guiding principles on business and human rights. And I think that this panel, this concept of talking about FPIC with natural resources, necessitates us to look at, to actually consider, or at least keep in mind, these UN guiding principles on business and human rights, the work of the Special Representative Ruggie, who had a mandate from 2005 to 2011, and now we have the working group on the issue of human rights and transnational corporations and other business enterprises. And actually that working group is going to be holding its second annual forum on business and human rights in Geneva in December, where they will be discussing issues of indigenous peoples. And in fact, the first thematic report being issued by this working group is about indigenous peoples. They went around and they asked different indigenous peoples, they held various consultations, and they said, what should we talk about in our thematic report? And everybody said FPIC. And in fact, FPIC was considered a tool that was easily accessible by the private sector, something that could be easily understood, cognizable. It's very difficult to try to translate substantive and really deep rights, you know, like the right to natural resources, for example, to a company with who themselves have limited capacity in understanding those things. And so FPIC was kind of characterized by the working group as something that could facilitate, you know, the incorporation of indigenous peoples in terms of participation, but also to attempt in some way to allow for indigenous understandings of their rights to somehow be reflected in these development processes. And so we've heard from our panel today that companies are doing it for themselves, sometimes with indigenous peoples, most of the time not, and a lot of time without government. And so I think that's really interesting. And I think the last and final points of interest that I find fascinating for the US is that you guys recently had a pretty major case using what I think you guys called the alien tort law. And so, you know, I was thinking about how a lot of your discussion today has been focused on domestic uses for FPIC. But I want to remind you that the U.S. has other international legal obligations under other treaties. So, for example, the U.S. is a signatory to the International Convention on the Elimination of All Forms of Racial Discrimination, a big mouthful which we acronize as ICERD. The treaty monitoring body for that is the Committee on the Elimination of Racial Discrimination. They reviewed the U.S. in 2008, and something that was brought to their attention time and time again, either through what are called urgent action early warning filings or through shadow reports submitted by civil society, is that the U.S. companies registered here in the U.S., conducting business in other countries, have been having negative impacts on the enjoyment of rights by indigenous peoples in particular. That was cited by the committee. And so in their report in 2008, they told the U.S. That you have to take appropriate legislative or administrative measures to prevent acts of transnational corporations registered in the U.S. which negatively impact on the enjoyment of rights of indigenous peoples in territories outside of the United States. At a time in our history when almost every country in the world has endorsed the UN Declaration on the Rights of Indigenous Peoples, I think we need to understand that type of interpretation of legal obligations read in conjunction with the guiding principles of the state duty to protect rights, the corporate responsibility to respect rights, and the necessity of an access to remedy. We must begin to think of things in a cohesive, holistic way that forces us to be critical thinkers, to be lateral thinkers, but I think overall better citizens. And I'm very grateful that you've given me the opportunity to share my ideas and thoughts with you. Thank you.